Chantal.
Okay, bye-bye.
Um, so welcome to this new online discussion on European administrative law, co-organized by the Review of European Administrative Law, Real Law, and the Yale Comparative Administrative Law MELSERV. It's a great pleasure to see old and new faces this afternoon. So let me just say a few words about the two initiatives, and then we will go on with the discussion. So, Real Law is first and foremost a Scopus and Fascia A-listed journal, and it seeks to advance scholarship on European and comparative administrative law, and it welcomes papers on any topics falling within that scope, especially from less well-known jurisdictions, so not only the usual suspect, France, Germany, and the Netherlands, but other as well, and also papers using different methodological approaches. Every second year, we will organize also a forum for young scholars with the best presentations being selected for publication in the journal. And this year, in September 2026, the forum will be held in Aix-en-Provence. So Riello is also publishing pieces, short pieces on a blog where relevant topics of European administrative law and comparative administrative law are regularly discussed. So if you want to contribute to any of these publications, you can come in touch with me and the Real Law team. The Yale Comparative Administrative Law MELSERV is an initiative resulting from an Edouard Algar research handbook on comparative administrative law edited by Professor Susan Rosa Kemal and her colleagues some time ago, and I suppose that many of you are familiar with that book. The main idea today is to foster an academic community of colleagues exchanging on current development in administrative law in their jurisdictions and sharing questions, ideas to develop project and possible collaboration. And this initiative is currently led by Oren Tamir, who is with us, and Mayelina and I are supporting this initiative as well. So today we are gathered for one of our joint initiatives of the online discussions on European administrative law, and we are extremely privileged to be joined by Professor Giacinto Della Cananea and Professor Angela Ferrari-Zubini, as well as with Oren Tamir. So Giacinto is Professor of Administrative Law at Bocconi University with a long track record of books and many publications on European administrative law connected to his involvement with renewal, for which he was awarded a Spinelli Prize, I think, in 2018. Giacinto is also publishing extensively on global administrative law with a book, I think, just published on that topic very recently. Angela is a professor of administrative law at Napoli Federico II University and an expert in Austrian administrative law and digital administration. So Giacinto and Angelo have led a European Research Center project on the Common Core of Administrative Law in Europe, with a number of books published in a dedicated Oxford University Press series. I think 7 books have been published to date, if I'm correct, but I think Giacinto and Angela will say a few more words during their presentation on that series. And there is also an umbrella book published open access with Brill in 2023, The Common Core of European Administrative Laws, Retrospective and Prospective, which is very close to my heart, maybe because there is a whole part dedicated to Belgium in contraposition with Italian law, and I found that very refreshing at the time. So Oren is an associate professor at the University of Arizona, passionate about comparative administrative law, especially the interplays between administrative and constitutional law. He was a postdoctoral fellow at Harvard Law School and an adjunct professor and global host postdoctoral fellow at NYU. So today we have this pleasure to be together to discuss the latest book in the Oxford University Press series dedicated to administrative rulemaking and planning in European laws. So we will proceed as follows. Giacinto and Angelo will kindly present their book for roughly 25 minutes or so, I think. And then Oren will comment on the book for 10 or a little bit longer minutes. And I will add my own comments before Angela and Giacinto respond. And then obviously we will open the floor to the audience and questions, and it's maybe the most interesting part, obviously, is to see how you react and what kind of questions you have for our speakers. So, Jacinto, Angela, I don't know who among you starts. Maybe Jacinto. Yeah.
Yes.
Yes, please. You have the floor, Jacinto.
Thank you so much, Isel, and all the other members of the team of your university, and thank you very much to Oren. We have been in touch, and it's great to have an opportunity to discuss. So, let me say, first of all, what we are discussing today. Suppose that parliamentary legislation or Congress in the United States authorizes a department or an administrative agency to give licenses to individual firms in order to obtain some kind of advantage. For example, a license for building and managing a resort. Or suppose that parliamentary legislation authorizes the administration to give money to individuals, such as welfare benefits. Or finally, suppose that there's an authority, the regulator of telecommunications or railways, which is going to issue new authorizations to provide services in that field. The question that arises is the following. First of all, is the administration authorized to set out rules or policy? And if so, should the administration consult stakeholders, including individual firms or individuals, including NGOs? And if those rules or standards or that policy has been enacted, should it be made public? And if so, will it become binding in one way or another, fully binding or just partially binding or so? These are the questions we have been examining in this book. And I would be glad to the organizers if they could show the first of my slides. So if you could move to the following one, because in the following 10 minutes or so, I will try to do two things. First, I will give you some very brief thoughts concerning the research as a whole, the research on the common core, as we call it, of European administrative laws, which Isel kindly mentioned initially. And secondly, I will give some details about the choices that we have made in this book with regard to the reasons why we have decided to focus on rulemaking and planning, as well as to the legal systems which have been included in our research. Now, from the first point of view, to make a very long story very, very short, due to time constraints, at the roots of our comparative inquiry, there have been two conjectures which we have tried to test throughout the last 10 years or so. The first is a conjecture concerning the existence in an important area of administrative law, that of administrative procedure, very broadly intended, not only whether there are common and connecting elements, despite many relevant differences, but also which type of common core does exist and whether it can be defined from a legal point of view in the sense that I'm going to clarify. And secondly, we have also tested a conjecture concerning the methodology That is, instead of having a juxtaposition, as the late Professor Schlesinger called it, of national reports, whether it was preferable to discuss, by way of a factual analysis, some hypothetical cases and then confront the solutions given by national experts in order to make sense of both commonality and diversity. Of course, there are very important issues in methodology. I will mention only two of them, but there's a long list of issues which we have been discussing throughout the years. One is the caveat made by my friend and colleague Paul Craig, University of Oxford, and that is really an important caveat concerning the limits of a factual analysis, because as he observed, not all issues can be examined by way of a factual analysis, because there are complex concepts such as those of rights or accountability, a concept which is not even easy to translate into some Latin languages such as Italian or French. Now, the other is a caveat which was made by Martin Shapiro, a very well-known expert of comparative law, with regard to the previous studies carried out in the field of private law. And that is to say, we should always be aware of the distinction between description and prescription in order not to try to find general principles. Now, that said, we have tested those hypotheses, those conjectures, in a number of areas, which you find indicated here, because we had several subtopics, including the traditional areas which the late Professor Dicey regarded as outside the field of comparison, judicial review and liability. Then we discussed adjudication, for example, in the field of expropriation and so on. We also carried out a couple of extensive analyses on the diffusion of administrative procedure legislation in Austria and Central and Eastern Europe, the first one, and more recently, Spain and Latin America. Now, our findings, very simply, are that there is a common core, which can be defined not only in terms of general principles and values, but also of what I would call mid-level standards, including the right to be heard, the duty to give reasons, and the duty to carefully gather and assess all relevant facts. But this common core is limited because beyond those mid-level standards and perhaps interpretive techniques, operational rules of the various legal systems and their practices differ, and sometimes differ remarkably. So if we could move to the second and last slide, because there's a third one which we might use possibly later. Thank you so much. Now, three quick things about our book on administrative rulemaking and planning. First, why we chose this subtopic. Secondly, the type of hypotheticals. And finally, one word or two about the legal systems selected for our comparison. Now, why choosing rulemaking and planning? It's very simple, because most comparative inquiries in our field still focus on administrative adjudication. There is nothing wrong with that, of course. Adjudication is important for many reasons, in many respects, and it's also easier from a certain point of view to consider from a comparative perspective. There are decades, if not centuries, of analysis of, say, expropriation or police powers. But at the same time, we thought that rulemaking and planning are interesting for a number of reasons. First, administrative rules and plans are important to define public policies. true, you can also have an idea of public policies if you consider, for example, how a nuclear plant is authorized, because it does have a huge impact. But generally, rules and plans have a huge impact on our social groups, municipalities, regions, states. And moreover, they structure the exercise of discretion, which can be exercised in individual cases. There's a book which was written some years ago by the late Professor Davis, and probably he foresaw some problems that we are witnessing today. I don't know, maybe Oren will say something about that concerning the powers of administrative officers who are involved in law enforcement or in patrolling the borders and so on. From a theoretical point of view, moreover, there's a strand in public law thought according to which it is precisely with regard to administrative rules that there's a divide between Britain and the rest of European legal systems, because administrative rules were regarded as necessary in Italy and Germany, for example, while in the UK there was a no-fettering rule. And finally, from a transatlantic perspective, it can be interesting to compare rulemaking in Europe and United States, because it is so important in the United States Federal Administrative Procedure Act, while some national laws in Europe neglect it. That said, the hypotheticals we have selected, and subsequently I will show one of them, concern various general standards, including consultation, participation, and transparency, and more than one type of control mechanism, including parliamentary oversight and judicial review. And finally, to borrow Isel's introductory words, we have sought to go beyond the usual suspects, in the sense that we have included in our analysis not only Britain, France, and Germany, still regarded by some as the major legal systems, but also others belonging to various traditions, administrative traditions in Europe. For example, Italy and Sweden belong to different areas, and legal systems belonging to the new member states of the European Union and to countries which are not members of the EU, such as, for example, Norway. And finally, we had chosen also the United States, China, and the EU itself. The underlying assumption is that legal comparison should be carried out not only with regard to the usual 3 or 4 states, but also outside the state itself. I will stop here because of time constraints, and I will be very glad to come back later with answers to the comments and questions which will be raised. Thank you, Isel.
Thank you very much, Jacinta, for the big overview of the project and some details about the specific book that we are discussing today. We will certainly come back to you with more questions in a couple of minutes. Angela, the floor is yours.
Okay. Is the sharing working?
No, because we see Jacinto.
Not yet. In this moment, I'm still there. Okay, good. Now it works.
Now it works?
Yeah.
Yes.
Okay, great. So thank you very much. As Jacinta just said, this book is part of the Common Core of European Administrative Law project, which he's conducting. I mean, he has been conducting since 7 or 8 years so far. So, aim and methodology of the book. I will go very fast on these first slides because Jacinto already said many things. So the book addresses a structural blind spot in comparative administrative law, which is the tendency to focus almost exclusively on adjudication and judicial review. While so we highlight the equally essential but less studied domains of administrative rulemaking and planning. About the methodology, Jacinto already said it. We follow the Common Core factual methodology, but also with some general questions that I will talk about in a little bit. So the structure of the book is structured in 4 parts. While part 1 sets out the theoretical and methodological premises, then part 2, as I said, presents national reports on the selected legal systems in which our national experts answered to 3 general questions that we asked them. And the general questions were about constitutional and legislative provisions on rulemaking and planning. The second question was about the legal effects of administrative rules and plans in their legal systems. And finally, which are the procedural requirements concerning rulemaking and planning. In part 3, we collected all the answers given by the national experts to the hypothetical cases that Jacinto was just talking about. And part 4, of course, carries out the comparative analysis of the answers. Why rulemaking matters? Again, of course, it is essential to move beyond the traditional adjudication center paradigm, as already said, because in many contemporary legal systems, the decisive moment in administrative action no longer lies in the individual decision, but upstream in the adoption of rules, standards, and plans. So administrative rulemaking increasingly performs a structuring function because it predetermines the content of future individual decisions and narrows administrative discretion. So this functional shift raises classic administrative law concerns, legality, transparency, participation, accountability, but in a procedural context that is often less formalized and less protective than adjudication. So the book starts from the premise that procedural fairness cannot be confined to individual decisions, but must also be ensured, or at least to see how it is ensured at the regulatory and planning stage. Coming to the purpose of the book is to carry out a comparative analysis of administrative procedural legislation on rulemaking across the legal systems examined. The book does not limit itself to jurisdictions that have adopted a general rulemaking procedure law. On the contrary, we also check whether and to what extent equivalent procedural constraints emerge in legal systems where rulemaking is regulated only fragmentarily or through judicial doctrines. So the analysis that I will do here very briefly is structured around this key dimension that I wrote here. So the constitutional foundations of rulemaking authority, the existence and content of procedural guarantees, and the availability and scope of judicial review. So let's start with constitutional foundations, because the comparison reveals profound differences in how administrative rulemaking is conceptualized and legitimized. Because in some legal systems, such as Germany, Austria, Portugal, and the Czech Republic, rulemaking authority is expressly recognized and constitutionally framed. So, and here, of course, the separation of powers is preserved through mechanism of delegation, specification of legislative objectives, and in some cases with parliamentary control. In other systems, rulemaking authority is either implicit or only partially acknowledged. Like, for example, in Italy or Sweden, constitutional texts do not provide a comprehensive framework for administrative rulemaking. And these differences are not merely formal, because, of course, they affect the scope of administrative regulatory power and the types of procedural constraints that can be imposed. Moving to procedural guarantees, which is a main core, of course, of the book, across the legal system analyzed, participation, consultation, publication, and transparency emerge as the most recurrent procedural requirements. However, their intensity and legal grounding vary considerably. In system with a general rulemaking procedure law, like Portugal or Norway, procedural duties are clearly codified and enforceable. In a system without such legislation, procedural guarantees are often derived from general principles of administrative law, such as good administration, impartiality, or protection of legitimate expectations. And of course, the courts play a crucial role in extending these principles to rulemaking. Something that must be noticed is that the obligation to give reason is frequently limited or excluded in relation to rulemaking. Moving to judicial review, which represents, of course, one of the most sensitive and controversial aspects of administrative rulemaking, some legal systems allow direct challenges against rules with general scope, recognizing their immediate legal effects on individuals. Other systems restrict individual judicial review to individual implementing acts. So they actually postpone judicial protection and increase, of course, the burden of the affected parties. And but even where direct review is excluded, courts often regain control indirectly by reviewing the legality of the rule in the context of an individual case. So again, here you can see that some general principles serves as the primary tools for which court use to assess the validity of administrative rules. So some comparative insights. The analysis does not point to a uniform European model of administrative rulemaking. Nevertheless, a form of, let's say, functional convergence can be observed, meaning that even in the absence of harmonized legislation, legal systems tend to converge around certain minimum procedural standards, particularly consultation and publications. And of course, this convergence is driven by courts, by judicial reasoning. And to conclude, I would say that rulemaking and planning are central to the functioning of modern public administrations, and they require procedural safeguards adapted to their nature, so not simply borrowed from adjudication. And the comparative analysis show the gradual emergence of a common core of procedural guarantees across legal systems. Thank you very much, and I will be also very glad to hear your comments and answer to them. Thank you.
Thank you very much, Angela, for this very clear presentation. Oren, I think you have some questions, comments on the book? Please.
Sure. So can you hear me, guys?
Yes.
Perfect. Hi. Okay, perfect. Hi. So good morning from Arizona. Thank you, Azul, for being just a brilliant colleague. Thank you, Danai and Chantel, for organizing this and all the support. And thank you, Giacinto and Angela, for writing a terrific, important book that was just exciting to read. Azul said that I'm enthusiastic about comparative administrative law. She's pretty right. I was enthusiastic also to read the book, and I think it's an important contribution. Let me just put some of the stuff that I think are just like a major contribution and make the book so worthwhile and important to read. So immediately you start the book and you start with the claim of the administrative law and comparative administrative law has the usual suspect problem of adjudication, and you broaden the lens and bring us finally into the kind of frontiers of administrative law, the stuff that we don't talk about, not enough in domestic administrative law systems and not in comparative administrative law. So that's a really important move. I do want to say there's a lot of nuggets or insights throughout the book that are just incredibly important. So you show throughout differences and similarities with respect to rulemaking and planning on the legal basis, whether it's a constitutional framework, a framework statute, or a completely sectoral analysis of rulemaking. You show really a rich array of breadth of how much consultation or participation in rulemaking and planning is required in different jurisdictions. You show in a way that I think about it in using from Jerry Mashaw's sort of terminology between the adjudicatory model and a more managerialist model, how some systems really still stick with a kind of an adjudicatory model as applied to rulemaking and planning, but some have really moved to a more managerialist framing, really important and deep insight. And of course, even though it's still somewhat within the usual suspect, you show important, incredibly interesting diversity and a commonality in judicial review of rulemaking and planning about the timing and scope. So to absolutely fascinating. And just I want to say two things that were just mind-blowing to me as an American, who's just so familiar, especially with rulemaking, with the notice and comment process. So, for example, it was so interesting for me to understand that some systems are kind of iffy or sort of don't enforce a kind of a duty of notice and reasons to the same extent that Americans are so obsessive about and have become potentially a problem in the US. So it was just, the thing that you expect from comparative law to kind of immediately challenge you and kind of get you to reflect on your own system, you get from this book just by reading and kind of summarizing your analytical, you're reading the country reports and reading your comparative and kind of more theoretical chapters. So I just want to say, congrats again on the book, and really to urge everyone to start reading it. Both enthusiastic people who are already kind of drank the Kool-Aid of comparative administrative law and are interested in this, and also people who are potentially on the fence and want to kind of understand why it's so important. I really encourage them to read the book. So, but let me to make the discussion interesting, let me move to a more kind of critical, or just kind of to try and get us to reflect about the book. So the way that I think I'll do it, or sort of to organize my own thoughts and kind of how can I contribute to a more kind of reflective discussion on the book. So let me point out what I think are kind of three, I'll call them missed opportunities for things to highlight throughout your project and to kind of come out actually indirectly from reading your chapters, and are of course motivated or kind of come from my own context as kind of embedded in the US system. So I will flag three what I call missed opportunities in the book. And then finally, if there's time, I want to suggest that there's something potentially in the methodology of the book that systematically causes the missed opportunities in a way. So to urge you to kind of, the Common Core has really important advantages, and the methodology I think has advantages, but I want to suggest that it has a kind of a systematic tendency to kind of have these missed opportunities. So here's one missed opportunity. So one of the really strengths of the book is that moving us beyond the usual suspects, beyond the 10-20% that we talk about, to the 80%. And then the focus of the book is about rulemaking. But here's something that was mind-blowing to me. I'm in the US, and to me, rulemaking is actually part of the usual suspect. All we talk about in the US, when I teach administrative law, I think 80% of the class that I teach my students is about rulemaking, about the notice and comment process. This is, of course, not entirely an old development. The US started with a focus on adjudication, but since especially the end of the 60s, 70s, we went through what we call the rulemaking revolution. It was clearly defined and conceptualized as the most important, the optimal vehicle for regulation, doing rules. And this is why the notice and comment, which is how we do rulemaking in the United States, is so central. So just reflecting on that kind of difference, I think there's a question here of a missed opportunity. Why is it within the kind of spectrum of countries that you're talking about, the US has actually moved to recognize rulemaking as such a central, perhaps the most important vehicle for regulation, whereas in other systems, it is clearly, as you show, a more ambiguous or really remain as a kind of a really unusual suspect, something that is not as central. What explains it? Is it something about the culture? Is it something about the kind of different trajectory of administrative law itself? Potentially the fact that really early on in the United States, early 20th century, a really aggressive doctrine of non-delegation, a separation of powers doctrine that would say that rulemaking is problematic as a violation of legislative power, was basically, again, kind of off the wall, was kind of overruled by the Supreme Court. It was clear that it's not going to do this. Whereas, as you show, in a place like Hungary, the hostility for separation of powers and rulemaking is still something very much so. So here's one missed opportunity. Why the US is so different about rulemaking? Is it law? Is it culture? What does it mean for the administrative states in the US and in other countries, given the place of rulemaking? Here's another missed opportunity, I think. Again, I'm suggesting a kind of a missed opportunity. I'm going to move from the kind of binding rules, to kind of more informal rules or kind of non-binding rules, what I think is within the scope of your research, what in the US we usually call guidance. So one of those, or another way to put this is soft law. Again, it's something that you definitely focus on, and you show in different countries how these guidance documents are part of a kind of, it becomes central, and how are they regulated? And I think this is really justified because guidance has become really important. Oceanic is one of the terms that we say in the United States when we talk about guidance. But here's another thing that I think your research is kind of maybe sort of identifies, but quite quickly puts to the side. In the US, guidance, these informal, non-binding documents that are really important in kind of structuring policies and kind of structuring discretion, are seen today in people are quite hostile to those documents. They are seen as problematically informal. They are seen as something that is done in a way that agencies are encouraged to do so because they circumvent the notice and comment process. They want to run away from a very cumbersome process to use guidance. And this really kind of hostility to this informal guidance significantly structured US administrative law with respect to this guidance. So here's another sort of maybe kind of missed opportunity. Why the US treats those guidance documents with this hostility. It has this idea that, this is a use that is something wrong with it. Whereas potentially, as I think Giacinto, you mentioned this in your remarks, that other systems, even though a system like the UK that started with a really strong no fettering principle, have moved away from really this hostility that characterized, I think, guidance in the past as something more welcoming or more in part as a kind of a normal standard administrative law. So here's again another question I think is pretty fundamental to thinking about rulemaking and especially informal guidance. Why are countries different in their approach to those documents? That I think is kind of interesting to understand, and how does that affect the operation of administrative law? I will also, a third missed opportunity that I want to say, another really interesting part of the book is about, you show how systems have struggled with the definition of plans and guidance? Is it rules? Is it adjudication? It's really interesting. And every system has this different solution, and that's totally right. But here's another thing that I want to point out that I think is a potentially something that was worth considering. At least in the US, there's two discussions about the role of these guidances from people who are less hostile to them that I was interested to hear. And I think it's potentially a missed opportunity to understand how they play out in other countries. One of them is that some people say that guidance actually, apart from rules and apart from adjudications, this idea of plans, that this is another kind of focus of the book, is actually the optimal way to regulate today. We are not, given the kind of deep uncertainty in regulation, both normative, technical, empirical, scientific, we can't really do binding rules, and we can't really move immediately to individual adjudication. What we need are exactly these tentative plans that would structure in a kind of general way discretion or policy. And only after we have these general broad plans, we can actually form, either move to kind of concrete adjudications or potentially move to more binding rules. So again, this suggestion is something different about how to think about these informal documents, informal rules or guidance. These are not in between exactly rules and adjudication. They have distinctive advantages to potentially be the optimal tools for regulation today in the administrative state. So this is a big and important discussion that is happening today in the United States. And I want to suggest one thing that it would have been interesting and potentially a missed opportunity. Is this another discussion that is happening today? Is this approach to those informal, non-binding plans or guidances as a kind of a rival to adjudication on the one hand and rulemaking on the other hand, is something that is really happening in other countries? Let me conclude by kind of, zooming out from these missed opportunities to suggest something broader about the methodology of the book. And I want to suggest why the factual sort of method, the factual approach, and potentially the scope of these particular project, the Common Core project, is potentially systematically allowing maybe those missed opportunities. So I want to start by saying something about the factual approach. I actually think this is a really powerful way to go about thinking about those issues. I do think that as a reader, I don't know if you've ever reflected on this, but as a reader of those factual approach, it's not necessarily the most stimulating read, right? In the sense that, you have to be, we're gravitating towards, we're thinking, we want the big theory, we want the big picture. And when you go to the factual sort of approach and you read country reports, you need some stamina and patience and to kind of bracket those big theoretical questions when you read them, because you are really kind of trying to, as you say, I think correctly, you need to have an experiential sort of approach to knowledge to see how law plays out in the wild, in the trenches. But I do want to say that at the end of the day, I do think that, and so I want to suggest that this factual approach sort of misses, in a way, theory, but then theory actually comes out, I think, from both Giacinto and Angela's chapters in 16 and 17. And this is why I was kind of like what I was looking through when I was reading those chapters and kind of got more or less in your chapter. So here's the theory that I think you kind of introduced to complement this. So for example, Giacinto says, there are three sources of constraint for rulemaking and plan, right? He says general principles, consultation, and political supervision. So I want to suggest, again, Giacinto is actually suggesting us a theory for this area of rulemaking. One is that general principles is a theory that constraint comes from rule of law and from kind of judicial logic. Consultation comes from a kind of a broader understanding of democracy, either as pluralist or maybe a kind of a more populist or maybe Republican. So that's another source of constraint. And political supervision is kind of a representative democracy, or maybe kind of another way to think about it is elitism. And essentially what Giacinto suggests, again, I think more implicitly, is that what is going on in different countries and their choices about how to structure the legal structures around rulemaking and planning is that we see differences between countries in their attraction to those different sources. Are we more about the general principles of law, more judicial logic, or are we more about representative democracy and political accountability? Or are we more about representation or about pluralism or about republicanism? So what I want to suggest in a way for me, even though the factual approach is invaluable in understanding how the law plays out, I am more interested in kind of thinking about those differences between and similarities between the states in terms, at the end of the day, of these bigger picture questions about what is the theory of democratic accountability or democratic legitimacy or administrative legitimacy of these forms of regulation. And then this is the final thing that I will say. And I think that what happens at the end of the day, is that if this is really kind of the one thing, the primary thing that would I would want to take out, understanding which countries are more drawn to those different theories of accountability, given the kind of rich texture of different forms of law on rulemaking and planning. I think that what prevents the focus on these questions is, in a way, the Common Core approach. Because the Common Core approach essentially glosses over those differences between those kinds of issues, between what is the theory of democratic accountability, because the Common Core approach, in a way, emphasizes something that, for me, for most of the countries within the within the kind of the scope of the book, are clearly a Common Core countries. They're all liberal constitutional democracies, maybe with the exception of China, the People's Republic of China. And this is no surprise that they're all trying to optimize or kind of balance different theories of accountability that are relevant for any liberal constitutional democracy, like rule of law and democratic accountability and democratic representation. So for me, it's not a kind of a big find to highlight, especially, again, putting China to the side for now, that there is a common core. For me, much of the action, all the play in the joints, would be the spectrum of different theories within the liberal constitutional democracy family, and which countries are more drawn to which are more elitist, which are more judicial or kind of rule of law, which are more pluralist, which are more Republican. So again, it doesn't need to be a focus for this project. The Common Core is invaluable in and of itself, but for future research, for future questions for the field, I think this should kind of move to be our focus. So again, thank you, congratulations on this achievement, and I look forward to your comments and to hearing Iseult.
Thank you very much, Oren, for your comment, constructive and reflective. I have also a couple of comments, and some will go a little bit in the same direction as those that are made by Oren, but from a slightly different perspective, I think. I want to make a couple of substantive comments, if I may, and then I have also some questions for Jacinto and Angela. So I think what I really liked about this book is the focus on plans. For the moment, we mostly have discussed rulemaking, but what I found was quite distinctive is this idea that plans actually need to be taken seriously, or much more seriously than they usually are. And in the books, it is mentioned, that there are urban plans, so the plans that we need to organize new housing estates, for instance, or new roads, but there are also plans which are of a totally different nature, those who connected to the recovery and resilience plans for the next generation EU. And we could go on with industrial plans such as the Rearm Europe plan for the moment, or the conversions plans for the Ukraine at the moment. So there are lots of different types of plans. And plans are, I think, difficult to identify with precision. I think page 7 of the introduction is saying that plans specifies the goals and objectives and then establish some kind of hierarchy between these goals and objectives. A plan indicates the means for achieving those goals. Normally, a plan is not directly binding, but it influences the content of individual decisions. Yes, certainly. And lots of research has been done. and is being undertaken on other European and national instruments, such as soft law and nudging, as has been discussed just a moment ago by Oren, but very much less research or attention is put on plans as a distinctive instrument, I think. Why? My guess would be that plants are very much connected to the type of economy that we had in the 60s and the 70s in a number of Western countries, and with institutions such as the Bureau du Plan in Belgium or Plan Office also in France. And actually, plants have stayed around, even though the planning economy has really moved away from the 60s or the 70s. The plan as an administrative instrument stayed with us, and expert in specific area of law, such as environmental law or planning, are well acquainted to that, but it's something that has been pushed to more expert area of law, field of law, and is not really taken seriously by more general administrative law, I think. So I think the dedicated study and bringing back plans in the discussions of general administrative law, I think, is immensely valuable. But obviously, it is a less well-charted area than other aspects of general administrative law. So the framing leads to also some kind of reflection. For me, the originality of plans is that the question whether they are distinct beast, something that is neither regulation nor an individual decision, but something that, and you mentioned that in your own words, that provides a blueprint for how the administrative decision, how the administration will exercise its discretion in the future. A plan is a way for me to coordinate action of different public and private actors, so that they bring their own energy, forces, investment towards a joint project that they realize. But the difficulty, I think, with plans is to try to see how plans are different from a procedural perspective. And there are questions you mentioned about participation, consultation, consideration, cost-benefit analysis, environmental impact assessment. But my question is whether plans, because they are, and very often plans can have individual effects and regulatory effect in the same plans, because all the parts of plants are not necessarily the same. I think they are not homogeneous or do not need to be homogeneous, and that's maybe one of the features of some plants. So the procedures also for adopting these plants are not so homogeneous. And maybe I'm asking this question because in Belgium, I would have a number of examples of plants which are hybrids between private law, public law, between regulatory effect and individual effects. And I would say, very generally speaking, there might be exceptions, but we tend to add procedural requirement in those cases, both the individual and the general requirements. So it means that we are really in the red tape best example, actually, when we are talking about plans. And I think there is something there that I would have liked to have unpacked in some form. Because at the end of the book, the last chapter, which has been written by Professor Garanta, I think, there is an attempt to do a taxonomy of different plants. And I think taxonomy, or the criterion for the taxonomy, is the kind of effects. Some plants have a regulatory effect, some plants have effect on general interest, some on individual rights. But I wonder if there are not other possible taxonomies which take into account this hybridity and how we deal with hybridity. And I will give you an example. A plan, an urban plan, has not just discursive content in the sense that there is a sentence, this plan provides that this and this, A, B, C, and D. Plans are also figurative, with figures, with the mapping of an area, with color coding and all these things. And the relationship between the color coding and the discursive part is not something that easy. Some answer will be that one is given the priority over the other, or that there is an equivalence between these elements. But also plans can be very long. There are things of 200 pages, 400 pages with lots of different maps, different scales of map, different overlaying of mapping. And the question then is, when you put that to consultation, which is your question about the procedural aspect, do we put everything to consultation with the fact that the individual citizen does not really understand what is going on because it's too long? In Belgium, we would have a perfect question: what if the language is not the correct one? And there are cases of the administrative judge where, because the language of the mapping was not the correct one from the language regulation, it has been struck, and 10 years of procedures have been lost in that way. But also the thing is that, do you want to put the whole plan to consultation, or do you think that for the consultation to be meaningful, you need to have some kind of summary? And then the question is, how do you put that summary? Is it something that you put in ChatGPT and say, "Poop, give me a summary," or is it something that needs to be piloted? Does it something that actually need to be consulted upon in some manner? So I think that plans, because of the technicality and these kind of things, requires a little bit of going in depth in the consultation requirements and digging a little bit into that in some manner, if I make myself understood. The point is also that you look at cases, and I think it's really a nice way to do something else in administrative law, to bring things that we would not otherwise looked at. But my question is that I have this sense, when I read the first part of the book, that there is some kind of analytical scheme to what the book is trying to do. The starting point is there are administrative procedures underpinning the rulemaking and the planning. The question is, are there general principles? And I think at one point in the introduction, the question is really, are these general principles linked to the rule of law understood in a Fullerian perspective? And when I look at that scheme, I'm puzzled by the fact that the first two cases are connected to political control, because for me, the scheme and the political control are not obviously linked. And I would have liked for you to explain why, for you, the first two cases needed in some ways to be connected to political control, because for me, it does not really answer the starting point of the scheme, except if we understand the rule of law in a very specific sense, the one of a more thick approach to the rule of law. But why would we go for that? I'm not sure why we should go for that. And maybe there's just something that I missed in the explanation or the reasoning process, but I would be interested to know about that. And my third point is about court. And Aaron said something about court. And I think for me as well, I was a little bit wondering. Obviously, we got lots of results and findings that are put forward, and that seems interesting. But also, when we are discussing regulation and planning, I was wondering if the same kind of project could not be done with different types of institution saying the law, being the mouth of the law, if you may say so, something like audit courts, for instance. Do you think that it would work or not? Or do you think that it's just too far-fetched to do that because there are different types of public bodies? Or do you think that it would be possible with some tweaking of some sort? But I would be interested to hear what you would say about that. And my last point is about something that I was very much toying when reading the book is, I would think that this book could be really interesting for the OECD, for instance, in its administrative capacity. Do you think that it would be indeed something that the OECD could read and extract some kind of toolbox? They like this word a lot, and that they could say, okay, we will read it, we will look at the conclusions, and there is something that actually we can use in administrative capacity building when we deal with Ukraine, let's say, if they are used for the process towards the enlargement of EU to the Ukraine. Do you think it would work? And if so, what would you think they would take from your book for that approach? Thank you very much. No question. Sorry, Jacinto, I saw that you had your hand risen, but I just saw it now. Sorry if I missed that.
Yeah, well, thank you so much, both Oren and Isil. These are really terrific points for discussion. And how do you want to proceed? I could give some answers. I could try to give some answers, and then Angela follows. Or Angela, do you prefer to begin and then I follow? Okay, good. So I go
start.
first. Okay, good. So okay, let me again and genuinely thank you for your kind comments. And let us now consider missed opportunities, issues in methodology, and the connections between the different parts of our analysis. Okay, so missed opportunities first. Why is it that while United States has recognized this area, in other systems things are different? So first of all, we do agree that there is an evident, manifest difference. I have some conjectures, again, as to the underlying reasons. And these are both cultural and institutional/political. Now, cultural first. Now, without entering into the details of a very complex kind of reasoning, let me say very briefly that in the German tradition, which has been largely dominant in continental Europe, the Administrative Act, the Verwaltungsakt, was conceived as the act which decides what the law is for a certain subject, with the exclusion of any type of general measure. If you read, for example, Otto Meyer's fundamental treatise about German administrative law, which he himself translated into French at the end of the 19th century, he made only one possible exception, what he called the collective act. That is to say, if you adopt a measure concerning a certain group of people who are in a public square, to tell them, for example, that circulation of vehicles is prohibited, or that they cannot demonstrate on that square. So culturally, there has been, ran a real difficulty for a long period of time, much longer than in the United States, to admit, if you consider some recent administrative procedure acts, you will easily see both in Southern Europe, for example, Italy, and in Scandinavia, it is easy to see that they have a clear focus on individual decisions. So the question might be, why is it so still today? One possible answer is that these cultural elements evolve, but they evolve slowly. But there is also another explanation, and since you are an American scholar, I wonder whether you might be interested in my other key. And I would say that in United States, the particular conception of democracy, which underlies not only the American Constitution in the narrow sense, but also what may be called the super statutes, that is to say, the statutes which have a constitutional status, such as the Administrative Procedure Act, has been a very decisive factor, a crucial factor in determining that there should be room for some kind of pluralism or participatory democracy with regard to rulemaking. Now, that is of course, not the whole picture, but I think that it is an important part of the picture. And coming to the other missing opportunity, which emerges from your initial comments, I think that you are totally right in emphasizing the evolution of UK law. Now, administrative lawyers have not paid so much attention to these in the past, but this is really, I think, a crucial factor. In the 1960s, when the very fortunate textbook written by William Wade, Administrative Law, was translated into Italian, the then most important, most influential public lawyer in Italy, Massimo Severo Giannini, said, look, this is really the model to which we should evolve, because it gives much greater flexibility to the administration, because they don't need to add new rules. It's a simple word. Once Parliament has adopted legislation, the administration is entrusted with all the necessary powers, and the courts will be reluctant to impede, to prevent administrations from acting. That was, of course, an oversimplification. It was an oversimplification already in the 1960s. And it is even more so today when, for example, in the UK, guidance is used increasingly, for example, in the field of participation in administrative procedures. Guidance serves as a sort of substitute for codification, because the UK legal culture still finds codification impracticable or to some extent suspect, while they have adopted various codes of practice or guidance. And in this sense, the point that you raised, guidance, is becoming increasingly important for the purposes of participation, because there you don't have the traditional principles of natural justice, such as audi alteram partem or nemo iudex in causa propria. And so that is an area where there is an increasing, I wouldn't say convergence, because I think that that word is biased and debatable. But you see that there is an area of agreement between European legal systems, which goes much beyond the differences of political systems. Now, will it continue or not? This is something we have to see. Now, let me say a couple of words on theory, and then I will turn to Isolde's comment. I think that once again you are right. The readers might find that there is a sort of hidden agenda about theory, because the book provides, as much as possible, empirical evidence. The book discusses descriptively things as they are. And then when you come at the end, together with a discussion or why, or the reasons underlying those differences and similarities, then you find theory. And so you may ask whether the author of that theory was a bit coward, or whether he tried to mask that theory. And the way I see it is that I've always been very concerned with an important strand of philosophical thought in Europe, that is to say, to build theories upon postulates, axioms, which are taken for granted. Take, for example, one of my preferred philosophers, Immanuel Kant. It is lovely the way in which he begins by saying that you have to deal and to treat everyone else not as a means, but as a goal. And we can find constitutional imperatives which are clearly influenced by the Kantian perspective. But if you try to build a theory comparatively on those postulates or axioms, you will find that there are major difficulties. For example, because we do agree to the rule of law in Europe, as Iselt may confirm, this is not just one of the values upon which the European Union is founded. It is also a general principle. We find it in a number of judicial decisions. But how is it conceived? If you dig beyond the surface, you see that there are, I would call them, thin and thick conceptions of the rule of law. Take the case of Hungary, for example. Now, Hungary is with us, and I always invite my Hungarian friends and colleagues to discuss with us, but we cannot conceal the fact that the conception of the rule of law, which emerges from Hungarian law as it is today, differs. So my suggestion is that we can certainly use general principles and political supervision, but we have to be aware that there are important elements of diversity, not simply persistent diversities, but also new diversities, new differences. And that is something which in itself may require a bit more theory. I agree with you. And probably we should, since the project is still developing in other areas, including both the exercise of authority, the exercise of coercion, and the management of welfare benefits, we will have opportunities to do so. So thank you very much again. Now, coming to Iselt's questions, and I will be more concise. I cannot agree more with you, Iselt, that plans have a very mixed nature or content, including figures and maps. I have, though, a couple of remarks. The first is that many lawyers, not those who are involved in this workshop today, but many lawyers, when they think about and they reflect about planning, they still think to the old theoretical framework of plans in the last century. And, for example, they are very well aware of the criticism made by Hayek and other economists against that planning. But today, consider Iselt, for example, one of the crucial elements of the European Union today, the EU Recovery Fund, and the plans that all national governments have elaborated and adopted with a view to obtaining money from Europe. Isn't that the technique of planning? Or consider, for example, one element we have in common with the United States. Now, whatever our politicians think and say about climate change, that's my euphemism of today, Iran. So I don't want to enter into a complex debate about how the US deal with climate change. We have evidence that especially the coastal states of the US, say, for example, Florida, South Carolina, California, they all are adopting schemes at state level, and they are encouraging local authorities to adopt plans at local level in order to comply with the consequences of the rising level of the seas. So there are plans concerning how you deal with seawalls, how you deal with existing buildings, and so on. Now, is it a sort of return of the Soviet planning? I wouldn't say that. Those are plans which must respect private property. They are plans which serve to organize the use of public funds, for example, for the renourishment of beaches. So we do have plans, notwithstanding very important institutional differences and different policies concerning climate change. So our argument is that those plans have both a substantive and a procedural dimension, and that it is more difficult to discuss the substantive dimension because it is linked with the different interests and cultural elements. But when you discuss about the procedural requirements for planning, well, we are home in the sense that we do understand each other more easily. And coming now to the other question made by Isolt at the end, could other public agencies be involved, for example, Supreme Audit institutions? It's a big yes. And I will tell you more, Isolt. Since we are now conceiving the questionnaire for another workshop concerning the administrative management of welfare benefits, we are already including some hypothetical cases concerning what happens if the audit institution makes an objection to how funds have been used. Now, clearly, that goes beyond the traditional binary logic, validity, invalidity. Because there are issues concerning the good management of public funds. And it is not easy to build hypothetical cases, but from a first attempt we made, there might be interesting opportunities, and I will keep you informed about it. I will stop here, and I apologize for the time I've taken, because I want to hear Angela and further comments from you as well.
Thank you very much, Jacinto, for the comments, for the answers, and all the doors that it opens. Angela, yes, please.
Yeah, no, actually, Jacinto already said everything. So since I also want to, no, I'm going to add something, don't worry. But since I also would like to leave the floor for the audience, I'm just going to do a very quick reflection on what Oren said about the first two big differences that he highlights. Why is the US, I mean, in the US, rulemaking is a huge part of administrative law, while in Europe, I mean, not that much. And why in the US, soft laws are today looked at with hostility, because they are seen as they try to overturn the notice and comment requirements. I think that these two reflections you made are connected from a historical point of view. I mean, in the US, you have the APA regulating rulemaking since 1946. So in the US, when administrative law, was built, or at least since the beginning, you do have rulemaking, and you have rulemaking in your APA since the beginning, since the 40s. So in the US, is normal to have a lot of procedural constraints or rulemaking because they are written from the beginning. In Europe, there is an opposite evolution. Like, if you take Javier Barnes' studies, he talks about first generation procedure, individual, and only second generation procedures, like with more than one person, and third generation as a historical development. So in Europe, rulemaking actually was conceived later. And since it was conceived later, and the APAs that we had since a long time, like the Austrian one or the German one that is more or less at the same time of the American one, they do not say anything about rulemaking. So in Europe, making it very generic, we do not have notice and comment or procedural requirements for rulemaking from the beginning. And therefore, soft laws, which at least say something about how it has to be done, for us is an improvement, while for you is something less than the notice and comment requirements you already have since 46. So this is just the very quick reflections I made while I was listening to you that came into my mind. And I just wanted to add this, but now I'm going to leave the floor to the audience for at least 10 minutes questions. But thank you. I mean, both comments made come to my mind lots of reflections.
Thank you very much, Angela. That's very kind. Do you have any questions in the audience now that we have spoken and talked a lot? Well, please do raise your virtual hand, and hopefully I can see you.
I think there was a question in the chat.
Sorry, I did not see it.
Yeah.
Jonathan, do you want to ask your question? I don't know if Jonathan is still there.
Yes, I'm here. Can you hear me?
Yeah, yes, please.
Yes, hello. First, may I say thank you very much for your holding this session today, and congratulations to Jacinto and Angela on your new book. And I already started to read. I went straight to chapters 16 and 17 to try to see the comparative synthesis. And thank you, Aaron and Isolt, for your comments. And of course, because a lot of my work is in American regulatory systems, I agree with Aaron's point about how significant rulemaking is. And we can talk more about that. My question that I put in the chat was just that it seems to me one major development over the last 50 years has been the rise of regulatory oversight bodies, often in the executive branch, but they could also be in the legislature, to supervise rulemaking, and more specifically to require an impact assessment or some ex ante or prospective evaluation, and then sometimes also an ex post or retrospective evaluation of the administrative action, rulemaking or regulation. And I would just, I tried to do some comparison several years ago, but I wonder if you have any thoughts today about the rise of these regulatory oversight bodies in the United States, in the European Commission, and also in the European Parliament and elsewhere around the world, or how they would fit in if you were to do another volume or another chapter, how they would fit into your study of comparison and a search for a common core. Thank you.
Thank you, Jonathan.
Good. Do you want me to answer, Isolt,
Yes,
or do you want to collect any other question?
No, go for it. Go ahead, please.
Angela, do you want to go first?
No.
Sure. I don't want to exaggerate. So first of all, thank you, John. It's nice to see you again, and I will send you a couple of pieces of ours which go beyond rulemaking. Now, your question is really terrific, because this is an important development, not only comparatively from a national point of view, but also comparatively from the viewpoint of the national reactions to EU requirements. Let me explain why the two sides of the same coin are both important. Now, from a theoretical perspective, I'm now using it, we tend to make a distinction between areas of agreement which are determined by what the French public lawyer Jean Rivero called les parallélismes des solutions. This is to say, you are facing similar problems, and you tend to use solutions which are largely similar, if not the same, because these solutions are driven by functional approaches. So, for example, you realize that there is much that is neglected by rulemaking institutions before they adopt rules. And in the different legal systems of Europe, there have been some solutions which are characterized by some similarities. But then you have, at the same time, EU law. Generally, initially, you have soft law, and then in some areas you have hard law. But also, and this is something which we couldn't examine in the first part of our discussion, but which should not be neglected. We have the soft law coming from the Council of Europe. So let me give just one example, which Angela will be able to develop, because she's our expert in the field of AI. And she has found out that the Council of Europe has been discreetly working in the last years in this field. Now, they do not adopt regulations or directives which are partially or wholly binding as those of the European Union. But they adopt recommendations of the Council of Europe, and sometimes they favor the certain conventions. Angela will explain it. Let me just say that in this respect, your question and the earlier analysis that you carried out together with Alberto shows that we could easily, for example, develop different approaches to the role of regulatory oversight bodies, in the sense that we could use hypothetical cases. And nowadays, since there are soft law and hard law coming from both the European Union and the Council of Europe, those hypothetical cases would make sense in all the European legal systems involved. But we could also have, and this is an element of diversity, we could also construct our analysis on certain case studies in order to see what happens in areas which are not covered by EU law at all, or which are reached only by soft law. So my answer would be that this is an area which is not only important but also timely. And I have to add, from a Southern European point of view, that probably there is also much that could be learned in this respect from the experience of other legal systems, which is also a way to answer to the previous question made by Iseult, in the sense, could the OECD learn from these? Possibly, yes. The problem with the OECD is that they tend to adopt a one-size-fits-all approach, which in my view is understandable but very dangerous, because we don't have simply functional necessities which are felt more or less in the same manner, but we also have very important institutional and cultural differences which cannot be eliminated by European guidance.
Thank you very much, Jacinto. Angela, do you want to add something
Oh, please do so.
No, just something very, very quick, since Jacinto mentioned AI, because yes, I've been working on the framework, the Council of Europe Framework Convention on AI, that actually a lot of the discussion that we have been, talking about today, and in particularly the comment made by Isolde before about consultation in planning, when a plan is like 400 pages, how do you put those kind of documents in consultation, because it's going to be impossible for people to actually really read it. That recalls to me also a new problem that is emerging with consultation to administrative decision that has been taken with the help of automation, of artificial intelligence. Because if you want to have access to the procedure that has been taken, if you get access to just the source code of the code used by the AI to decide, normal people just are not going to understand absolutely nothing, anything. So it's something that, of course, very different, but the problem underlying it is very, very similar. Because if you want to consultate people in a procedure, planning or rulemaking, where some decision will also be taken by AI, how do you do it? So also AI in this respect will be problematic and will need to be further analyzed.
Thank you very much. I'm a bit sorry because I see that it's time to let go of the conversation when actually we have lots of things that we still would like to discuss. I don't know if there's any kind of very hot question, or otherwise we can probably keep the discussion with the email or whatever among us. No specific questions. And what maybe, Orent, because we haven't heard from you in the last 20 minutes or so. Any last words?
For me,
about the book, and then I will close the discussion.
No, it was. I want to say how much I benefited from reading the book and hearing from you about the more theoretical, cultural, legal aspects, which I think really is kind of the next conversation that we should have after you've done this impressive research. Maybe just an interesting thing to say, Angela. I found the theory really interesting about why rulemaking is so important, and informality has kind of been seen as with hostility in the United States because of the APA. But here's just a nugget that somewhat complicates this interesting and probably weighty theory, is that actually, even though in 1946 there was these provisions about notice and comment, the United States hasn't seen a real rise in using notice and comment until basically the 70s. So in a way, this is, I think, a global trend that we started our administrative states as a kind of an adjudicative administrative states. We moved to rulemaking probably later on. And probably we actually, in a different world today, I would suggest, this is a kind of a provocative suggestion, that we're no longer in an administrative state of rulemaking, but we are in an administrative state of exactly plans and guidance. We're kind of in a third step of evolution of our administrative states. But I just want to say, the US has also had a relatively modern development, but still it is a central one that really preoccupies the minds of everyone in the United States, and it's not the same elsewhere. So it's still pretty provocative. And we will have to, although the APA is probably part of the explanation, it can't be the only thing. We really need to go to culture and politics and maybe also constitutional law. Anyway, so just a kind of a reaction to this.
Okay, I think there are lots of things to discuss, and maybe we can frame a different conversation in a couple of months to keep the conversation going. So sadly, it's time to close, but I thank very much the speakers, Jacinto and Angela and Oren, for the contribution, also the members of the audience, and hopefully you can also come back with comments to the authors at some points, because there are definitively new research area that are being discussed and are emerging from our discussions. So we are very much at Real Law and at Yale Comparative Administrative Law myself to welcome you to similar discussions, and actually very soon, because tomorrow evening for me we have another fascinating discussion on the case Cook versus Trump in the US, and we will discuss this case with experts. So Diane Fromage, Louis Genio Garcia, Shirin Morris, Michael Ioannidis, Michel Salip, and David Saring. So please do join us. If you have all the details on the Real Law LinkedIn account, if you want to join, you are more than welcome. And I wish you the recording.
I will. Thank you so
Excellent.
much.
That's great.
Goodbye.
Thank you very much.
Thank you. Thank you very much. Thank you.
Bye.
Bye.
Thank
See
you
you.
and congrats again.